Hi, I'm Tyson Franklin, and welcome to this week's episode of the Podiatry Legends podcast. With me today is Dr. Cam Wareham. He's also professor. Now, Cam has been on the podcast before, and it was a really, really cool episode. It was the harder you work, the luckier you get. And that was back in episode 102. And today we're going to talk about a topic that, if you don't think this is really exciting, then you need to think again. We're going to talk about medico-legal aspects of practice and dispute resolution, which I tell you, this is so important part of our profession. So Cam, how are you doing today?
Yeah, great. Thanks, Tyson. I'm baking over here. It's super hot, believe it or not.
What do you class hot? What do you class hot in the
UK? 34 degrees in London today.
That is hot. That'd be dropping like flies, wouldn't they?
Yeah, you can imagine London just isn't built for 34 degrees at all. So yeah, it was pretty smoking hot today. So it's hence my white linen shirt. So yeah.
It's funny. I was talking to someone in Brisbane the other day, and everyone was complaining about how cold it is in Queensland at the moment. Yeah, it went under 10 degrees. And I said, the funny part with Queensland, I think in general, our homes are designed for warm weather. So everything's open, breezes going through, large balconies. So it's the exact opposite. We're not really built for cold weather. So when it gets really cold, we freak out. And I think the UK, I've been to the UK once, and I've seen some homes there, and they're not really designed for hot weather.
No, I mean, look, I'm sitting in the kitchen now, the fan's on, and we have heating, but no AC in sight. And it's really muggy. It's the difference between, being in Perth a couple of years ago, 34 degrees is pretty normal, but it's tolerable because it's a dry heat. Whereas over here, it's really sticky and muggy and generally unpleasant at 34 degrees, especially in London. So,
And I've been to Arizona, and when I've been, there's been like 40 degrees. But it's like you said, it's a really dry heat. When you're in the sun, it's like somebody is slapping you with a cricket bat. It's uncomfortable. But as soon as you get out of the sun, you're in the shade. You go, actually, doesn't feel hot.
No.
So anyway, we're not here to talk about weather conditions today. No. We are here to talk about medico-legal aspects of practice and dispute resolution, which you are a bit of an expert in this particular area. But before we get started, how did you get into this part of podiatry? Even though I've talked about your career becoming a podiatric surgeon, but what got you into this aspect of podiatry?
I think it's a bit of an insidious slip into it. Most people who do med-neg type of work generally get invited to get involved somewhere along the line. And it was the same for me. So I was a consultant back in 2006, and a colleague of mine in another hospital was having a run of complaints made against him. And so what happened was the trust decided that they needed an external opinion, one that wasn't commissioned by their trust solicitors and one that wasn't the opinion of the claimant's team, and to have an independent view across things. So I got into that side of things as far back as 2006, and from there, I started to do a few more courses around medical negligence and expert witness reporting, and I guess it just snowboarded. So once you get known on the circuit, so to speak, you start getting invited to attend events, and in my case, instructed in a lot more cases. So it's a long time, but for me, I feel the pain. Like just about every single podiatric surgeon around the world, I've had my ass slapped a few times, and it's an uncomfortable experience. And
but we're still talking about podiatry, aren't we?
We are still.
Yeah. Okay. Just checking. We're still talking about podiatry. Yeah.
So that discomfort is keenly felt, and I've always taken a view that the more people that are involved in medical expert witness work, the better it is, because rather than taking the view that it's someone who's out there to bury every single podiatrist in the world, it's actually someone you'd rather know them. You'd prefer to know the person who's writing the opinion, perhaps against you, because they're going to be fair and balanced, and that's the name of the game. It's being fair and balanced and taking the court's view on things. So I did a lot of expert witness report writing, and probably in the last, I don't know, the last 5 years or so, I started off my undergraduate law degree quite a few years ago, and put it aside, and continued on my life as a consultant podiatric surgeon doing some expert witness work. But I then picked it up again and converted it into a master's in law in dispute resolution, which took me into the field of, so it took me into the field of not just expert witness work, but actually learning about the alternative methods or the different methods of dispute resolution, which are more negotiation, mediation, and arbitration. So a slightly different take on things, but really, really interesting. So
yeah, my brother's a dentist, and he injured his hand for a while and couldn't work. So he thought, oh, I don't know if I'll ever be able to go back. So he went and did a law master of politics and a few other degrees while he was off. And he said, every person should have a law degree. He goes, it is such an interesting course to go through.
Yeah.
And he was actually thinking at the time, sort of what you just went through, where he went, well, maybe I might become a lawyer, but his goal was to protect dentists. But then eventually his hands came good, and he went back into dentistry.
We're bound to be in dentistry. But, look, that's a really interesting point, because I think just about everyone who goes through the process has got a story, and I've got my own story. And I think, for me, it was very much about, I had a claim made against me, and for the life of me, I couldn't fathom why this claim had turned up. I thought I'd got on great with the patient. I thought the outcome was fine. It was, it was good. And suddenly, a couple of years later, I get a letter on the doormat, so to speak, or through an email through the post, saying that we want a copy of the medical records, and lo and behold, it then rolled on, and I suddenly got into the situation of having to send notes to my professional organisation, them taking them away for a while, getting a phone call out of the blue from the solicitor saying we're dealing with this complaint. And all the time, I felt there was a horrible feeling of unfairness and a real lack of control over the process. I was completely out of touch with the process that was going on. Didn't know anything about it at that point. And really, for someone who likes to be able to control things in front of me, I like to be able to control the situation I'm working on, etc. I was out of control. I didn't like it. It was a very uncomfortable experience, and I found myself trying to say, but that's unfair. And one of the solicitors said, this is a bit of a game. It's a game. You have to just put the emotion of it being terribly unfair aside. You'll be surprised at how often claimants are sometimes quite happy with things, and they'll be jovial, but yet they go away and write terrible things. And when you see the letter of claim, it will be that you're the worst person to walk the face of the earth. And I was horrible. 37 different allegations of I'd done horrible things, including waking up in the morning and going to work and breathing oxygen, sort of thing. So
would you say a lot of problems that come about, though, like there probably are some podiatrists that should be sued, are incompetent, are doing things outside of their scope of work, and are genuinely making mistakes. But we say majority of podiatrists think they've all done the right thing, but the patients don't see it that way.
Yeah, look, I think there's a fair bit of research that's been done quite a while ago now, late 90s, early 2000s, and why people sue. And invariably, it's if you break it down to why they sue, it's not always the fact that you've accidentally shoved an E11 blade through their foot. It comes down to sort of, they're just generally unhappy, then they become more generally unhappy, or the outcome isn't quite what they wanted, or whatever it might be. And it always boils down to a breakdown in communication. So you can actually, sometimes you can't pick the patient. You think the people who are going to complain don't make a complaint, and yet the people you bend over backwards for often are the ones who actually end up making a complaint, because it's not always them. They go and talk to their relatives, just unhappy, and people say, "Oh, that's terrible. They didn't do that. My friend's mother went to a podiatrist and they said you should have that done." And actually, the research shows that although the claimant has to sign the form, they've almost always been put up to it by someone else.
That makes sense. Hey, going back, I want to go back to your story, though. We didn't finish it. So what happened with when you went through this ordeal yourself? You were saying it's feeling very unfair.
Yeah.
What ended up happening?
So in the end, we admitted liability on one aspect, which was more of an administrative aspect of the way that the patient hadn't been able to access the department in a timely way that they wanted. But in the end, it was defended to a point where the patient ended up being paid out a sum of money.
Yeah.
And they went away having signed a non-disclosure agreement, and it was settled. And I was livid. I was cross. I was angry. I wanted to sort of jump up and tell the world that it was unfair, and how could they just walk away with an amount of money, because I didn't think I'd done anything wrong. And still to this day, I could read the report now and say, well, I think it was probably defendable, but it's always a bit of a toss up between what's economical to settle. And when you realize that actually perhaps sometimes you're not the client anymore, actually your insurer is the client.
Yeah.
So the person's suing your insurance carrier, and they make the decision about what they will defend and what they won't. And by and large, it comes down to understanding that if you're working for an employer, you're under vicarious liability, you're an officer of that employer, and they will defend themselves based on their advice given to them, which may well be a purely economic decision. So in this case, the patient walked away with a sum of cash, happy. I didn't think that they had a claim, but I just felt that it was grossly unfair through the process. So I thought, I'm going to get into this area of work because I want to be the guy with the cape defending podiatrists against every horrible patient that comes through the door. And of course, it's not like that.
Yeah. And wearing your underpants on the outside of your trousers as well.
Absolutely.
With your coat. I've only ever, over my whole career, 30 plus years, only ever had one letter from a solicitor where someone was complaining about treatment. It wasn't me, it was someone that was working for me. And the letter from the solicitor basically said, please give us the details of your insurer. We want to, and I sent a letter back and went, no. Which really threw them, because they were just expecting, they'll go, well, here's my insurer, I'm going to panic. And I didn't panic, and I went, no, I'm not going to give you the details of my insurer. Why would I do your job for you? You figure out who my insurer is, and we'll take it from there. And then I wrote something else about that particular patient because I knew who it was, and I knew what they were saying was, I said, it's a false claim. I'm not going to give you the insurer, and it's a false claim. I said, please get back in touch with me. And we never heard anything past that point, which that was the only one that's ever even remotely come close.
Do you know, look, that's an important sort of point, really. Sometimes it depends how confident you are about the claim that's in front of you. If you remember the patient and remember that things didn't quite go according to plan, you'll be perhaps less keen to give the information to the solicitors. But the reality is that you rely on the solicitors, and you rely on the expert witnesses to do the work for you. And so communication in that form is key. But sometimes the solicitor will do the job for you and come out with a fairly aggressive stance of deny, and that's okay, depending on how the case runs. But it doesn't always have to be that way. There's a lot of times, I spend my time going between being formally instructed, in which case then really it's about me just looking at the job in front and understanding the claim and trying to find out what's gone wrong and writing an opinion based on the evidence as to whether or not this person has got any merit in their claim or not. But before that happens, I often get contacted and before instruction, get contacted by solicitors who will ask me about a case and where it's heading before they instruct me, and they do it for a reason. So before they formally instruct me, they can ask me what I think, and they can ask me where I think the potential weaknesses might be, or what sort of angle for defence might be necessary.
When they're getting your opinion, though, are they giving you a copy of the patient file and just getting you to read through all the notes and what the claim is, and just going, okay, I can see the whole. You're looking for holes. You're almost like a mini detective, looking at the evidence, looking at the complaint, and saying, okay, where are these things actually matching up?
Yeah, so it depends where it is. So if I'm formally instructed, then no, that doesn't happen. I get a full brief, which is I get the letter of claim, I get my instructions, which are to perhaps normally answer a couple of questions, but I'll get the full patient's file. And often it won't just be about the treating practitioner. In my case, for example, it might be the GP notes, the podiatrist's notes, the other vascular surgeon's notes, the orthopedic surgeons. I get a oversight of the whole lot, including all of the medical records. So I can look from, look at the ECG that was done 40 years ago, for example. Totally irrelevant, but they always seem to put it.
Got to have it in there.
Yeah. So once you're instructed formally, that means that you are working on behalf of the court. So your duty is to the court rather than the side that has instructed you. So you have to be down the line, absolutely fair and absolutely unbiased. And that's important because you don't ever want to write a biased report. It just never goes well. It doesn't go well for the client that you're working with, and it certainly doesn't put you in good light with the court. But before that stage, before you're informally instructed, I'll often get a phone call or maybe sent an email saying, this is the claim, this is what's happened, and this is where we think the problem is, and I can give you a little bit of information. And on that basis, do you think this is worthwhile defending? And so I will tend to sort of do what's called a short form report. And on those situations, they're not court reports, they're for the instructing solicitor to advise them. They're more of an advisory opinion as to whether or not this has got any claim, any merit to the claim, at which point settle it now or defend it. So that's what I tend to do.
So so the process that you're going through, has this all become like what you're talking about here applies to all countries? This is not just like you're in the UK, like you're in New Zealand to start with, aren't you? Right.
Yeah.
You've worked in Australia for a certain period of time at the University of Western Australia. You're now in the UK.
Yeah.
So are you saying that these are like standard rules that apply across all countries?
Yeah, it depends on the system of law that you work with. So Canada, America, North America, Canada, Australia, New Zealand, all work on a common law jurisdiction. So does Scotland and Ireland to a degree. So generally what happens is you're not really being instructed for your understanding of the law. You've been instructed for your understanding of what common practice is at the time the event occurred and what the average person would do. So a similarly trained and qualified, experienced podiatrist, what would you expect them to do? And the report goes on that basis. So it's less about the law in the jurisdiction and more about the treatment per se. And that seems to be common throughout all of it. It just so happens that I happen to have a law degree as well. So I do understand the elements of negligence and what is negligence, because it's an important point. People do start doing expert witness work, not understanding what actually is negligence and what's not negligence. You'd be surprised at how many times in a conversation you hear people say, "Oh my God, that was terrible, that was negligent." And if you're that person at the party, you say, "No, it wasn't." So,
like it'd be that you're going to be that person.
Exactly. So you turn around and keep quiet, but it's important when it comes to the case to say, well, that actually isn't negligent action. And by the way, negligence is not my opinion, it's the court's opinion. Negligence is a legal definition, it's a legal decision. So we can always say.
So you're saying that if somebody does everything right, they do it by the book from start to finish, they have not done one thing that is negligent, and the outcome isn't what the patient wanted, that's not negligence.
I mean, if sometimes that's, bad luck does happen, things go wrong, and provided that you can defend your. Do
they have a legal thing for shit happens? There's no legal standing for shit happens.
Yeah, well, it is. It's on balance of probabilities that these actions were reasonable and defendable. That's the balance. The on the balance probabilities test. It's about whether or not On the balance of probabilities, would this have likely to have occurred or not? And that is the standard of proof in civil cases. So all of our cases in negligence are normally civil. We do have some crossover to criminal law where you can be criminally negligent, whether you've done something just so woefully bad or without any due care of attention, and you put someone at risk to a point where it's criminal. That starts to move into a very different forum. That is beyond reasonable doubt, as we all know it from the movies and the TV.
Yeah.
But by and large, it's the balance of probabilities. Did it occur? Did it not? And that's a 49%, 51% possibility. And it's different. You don't have to prove 100% negligence in order to be successful on the balance of probabilities. You have to show that it more than likely did happen rather than it didn't. So patients have a bit of an uphill battle. I wouldn't like to say, given that we're speaking to professionals in a professional forum, I'm obviously going to talk about sort of defending podiatrists. And it's not to say that patients have an easy time of suing. They don't at all. They actually have quite a lot of work to do to bring a case to success and prove on balance of probabilities that things went wrong, because you've got to satisfy a number of elements in order to prove negligence. You've got to have a duty of care, which kind of is as easy as if the patient comes to you and walks in the room, you have a duty of care to them. You've got to then have done something which is below the standard of care in terms of treatment or diagnosis or delayed diagnosis, or not treating them. So that action has to be below the standard of care of what would be expected of a reasonably qualified and competent or experienced person similar to you.
So would you say when you've been doing all these claims so far, have most of them been podiatric surgeons, or have they been general practicing podiatrists?
Yeah, general practicing podiatrists. So you've got to work on the basis of what comes in the door, and also having an expert witness practice that goes across all of the field. Because whilst you can restrict yourself to podiatric surgery if you want to, the cases are bigger, but they're not that frequent. Actually, the frequency that I see diabetic work is quite alarming. There are lots and lots of diabetic foot negligence claims.
Yeah.
The other one is warts, believe it or not. Warts.
Two things I don't like.
No.
Oh, not that I don't. I'm sorry. If you're a diabetic patient, it's not that I don't like. Oh, you're a diabetic. I don't like you. But I don't like ulcers. I don't like wart. I don't like anything like that.
Well, so look, just going back to complete what I was just saying before, that the chain of events has to result in harm. It's got to actually do something. You can't just say, oh, he did it wrong. Well, was the outcome good? Oh, yeah, the outcome's fantastic, but he did it wrong. Well, that's not a successful claim. It's got to have been, he did it wrong, and I ended up with no leg.
Yeah.
So that's where the chain of events is completed, and that's a successful claim. But yeah, diabetic patients often end up claiming against podiatrists because, sadly, we're often the last ones to have touched the foot before the patient then ends up in A&E, having a failed revascularization that ends up in an amputation. So I'd say that actually diabetic patients form a large part of the work over here in this country, at least anyway. And in other countries where I'm instructed, so I am instructed throughout Australia, New Zealand, the UK, Scotland and Ireland, mostly. Those cases tend to be more related to biomechanics, and they tend to be related to orthoses specifically.
Is that like an injury resulting from an orthotic being made, and they weren't happy with the outcome, or something got worse?
Yeah, sometimes you do get cases where patients will come across and say, I've got a bad back, and it must have been because the podiatrist gave me something in my shoe which altered my gait. And by and large, those sort of claims are slightly difficult to really do anything with, because whether the science is there is difficult to justify. But invariably, those cases have been prompted by someone else. By another professional, I might add.
Yeah, I was going to say, because if somebody, let's say I saw a patient, did my examination, did my diagnosis, made an awesome orthotic for them, fitted it, everything was great. And then they go off and then something else happens in their life and they're blaming the orthotic, and I know it wasn't.
Yeah.
The other side, the solicitor from the other team, wouldn't they have to get another podiatrist or another expert to say why the orthotic was wrong?
Yeah, so it goes like this. The patient effectively goes away and says, I've got a sore back, and they may, I'm not going to pick on physios, chiros, or orthopedics.
Oh, no, we can pick on them if you want. It's fine.
my cousin's a chiropractor.
No,
so
no,
I
got very close friends who are chiropractors and physio, so no, we won't pick on them.
Yeah. So they might go to another practitioner, let's say that, and they say, oh, it's because you've had this done or you've had that done. Did they do a full biomechanical or whatever it might be? No, well, they didn't do that. They certainly didn't do that. Did they do a 3D gait analysis on a treadmill with lots of cameras? And no, they didn't do that. Oh, they didn't. Oh. So all you need to do to sow that seed of doubt in that patient's mind is go, it's the proverbial sucking of the teeth or tut-tutting that the mechanic does. And he goes, when you go in with a rattle, they go, it's going to cost you thousands. It's that sort of tut-tut. So it's that proverbial sort of comment or not comment that can often prompt things. And actually that's what podiatric surgeons suffer with, to be honest. It's actually, if patients find their way to another practitioner who says, oh, right. Oh, okay. Oh, who did you have it? Oh, I don't know him or her. Oh, no, I don't think they're part of our crew. Those sort of things begin to build up in the patient's mind that something might not be right.
So it's just small little comments. So even because this may surprise you, but I've heard some podiatrists complain about other podiatrists' orthotics. I don't know.
To the patient?
Yeah, to patients. Have you ever heard that comment happening? And
yeah, I have.
Yeah. And I often wonder, does that sometimes spark, like I mentioned someone to you off air, a local podiatrist in Cairns, which I won't mention their name, won't even say if it's male or female. And and a lot of the times I've heard things about, patients have come to us and we've probably gone, oh, you saw them, did you? Okay. But to my knowledge, they have never been sued. So how do some podiatrists fly under the radar? How do they manage to get through their career and not get their butt kicked when you sit back going, my God, they're incompetent?
Well, if you look at what patients sue for, so most people think they sue for sticking the E11 blade into the sole of the foot by accident. That's actually not what happens. Invariably, it comes down to the number one reason is a breakdown in communication. They tend to sue, patients tend to sue because they have had somewhere along the line a breakdown in communication with the practitioner, which has made them unhappy, or a minor complaint has turned into a slightly bigger issue because they feel that they've had to go elsewhere, or that practitioner has spoken to them offhand or told them that their pain is in their head, or lots of other things like that. I can talk for hours about. The breakdown in communication is almost the number one factor. So to answer your question, invariably you find that those people have got normally quite a good method of keeping their patients tight and close, or they work very closely with them. Or sometimes they do simple things like they just pay them off. They come in with a complaint and they have a complaint about something and they cash to go away. And some patients are.
I have heard that happening.
Yeah, although by and large that cash is actually about third down on the list.
Yeah.
The number one thing that patients want out of litigation processes, they don't want anything to happen to someone else. So invariably, when they go and talk to their relatives, friends, or their doctor or another clinician, it's on the basis that they don't want things to happen to someone else. They then want an apology, or they want to understand what has gone wrong if they perceive it's gone wrong. Then they want some compensation for the harm or distress that they've had. And then after that, there's various other bits and pieces that go down towards the end. But actually, the top three are those factors. And people who don't get sued are very skilled at keeping the patient happy, dealing with their complication or dealing with their complaints very, very well, very skillful, and they tend to fly on the radar, under the radar quite nicely.
Mm. Yeah, and I'm sure that every profession is exactly the same, and even outside of the healthcare industry. I mentioned to you before I press record, you go to a restaurant and you're not happy with the meal, or you feel you got food poisoning, you got sick from their food.
Yeah.
The first thing you want is an apology.
Yes.
That they accept, wow, we're really sorry that happened. Not, oh no, you couldn't have got it from us, you're an idiot. Because as soon as they say that, you would get your back up.
Yeah.
And straight away, then you're going down a different path.
But sometimes, it's about couching that apology, or that, we have a duty of candor, don't we? Which is to basically tell the patient that something's not right.
Yeah.
So we always have that. I mean, that's a registration standard, no matter which country you're in. You always have to be honest and upfront. And if something's gone wrong, you honestly say to the patient, look, I'm really, really sorry you find yourself in this position. It's not what I want. I know it's not what you want. But what we can do is work together to get through this process. You stick with me and I'll stick with you, and we'll see you through this. If you turn around and say, sorry, I'm really sorry I did this to you, if you truly believe that's the case, well, that is one way of doing things. You might find that your insurance company would rather you didn't admit it at that point.
Yeah.
But there's nothing wrong at all with saying, look, I really, really empathize with you. I'm really sorry it's happened to you. I didn't want you to get this nasty post-op infection after your PNA. And I'm really upset. And you've been on my mind for the last few days, which is why I've called you 3 times to check to see how you're doing. I don't do that for every patient, of course. So I think if you're open and upfront with patients, and you have got that real compassionate, empathetic approach to them, they more than likely will stick with you. And the one thing they won't do is they won't go and talk to their relatives and say, you know what, I felt abandoned. I felt that he wanted to see me, he wanted to do the surgery, he took the money, but after I had the operation, he wasn't interested in anything else. Or I got the orthoses from him, but he didn't want to see me after that. That was it. And actually my pain hasn't gone away, it's got worse. So I kind of felt abandoned. And I think realistically, keeping the patient close to you is super important. Communication is always the key in these situations. I've heard
that from law. At a conference once, I had someone from one of the insurance companies come in and do a talk. And that was the biggest thing I took away from it, was they said one of the biggest reasons podiatrists get sued or other healthcare practitioners is because of the breakdown in communication. It's exactly what you're saying.
It's interesting. So the NHS is trying to move away, or trying to reduce litigation, because it's so expensive. It's costs the country billions every year. Claims sometimes have a merit, sometimes they don't have merit, but they still cost money to defend. Yeah. So what we're trying to do is move it into dispute resolution methods. So things like mediation with a professionally qualified mediator who's also a healthcare practitioner, who understands the conflict resolution techniques, understands the law, but also understands the medical side of things, so that you can get the healthcare professional in the room with the patient. So the patient can get the apology that they want, and they can get to see that the healthcare professional is upset, is reflective of what's gone on, but also that the healthcare professional gets an opportunity to talk and say, because, it won't surprise you to know that every single person I've ever done a case for has felt terrible. You can see it in the emotion coming through when I ask that they write a statement, or statements included as to what's gone on. It's laden with emotion. Actually, the facts are about this much, but the emotive is 2 or 3, 4 pages of emotion, sometimes very angry emotion as well, which I totally understand and sympathize with. And actually, when you get dispute resolution techniques where you have got mediation, negotiation, and even if it comes to a settlement or an agreement of some description, with a professionally qualified or help or mediator, you can get good results so that the patient doesn't go away and start suing. They're always couched in the terms that you've got to have 2 parties prepared to mediate. And the mediator's job is not to decide on the outcome. It's to help the parties come to a solution and a resolution. There are forms, there's forms of medical arbitration where someone like me, who has got legal experience and medical experience or healthcare experience, sits in a semi-judicial capacity and decides on the case. And those sort of cases are presented by solicitors and barristers, and they present them very much in a court-style fashion. And it's where there's a move for that more in the USA, because they want to keep those records out of court. They don't want them to be reported on publicly, because of course all court records are public. You can read what's gone on. So arbitration is a private court, if you like, where the settlement is binding. And then importantly, you have the ability to appoint an arbitrator who is healthcare or medically qualified. So a judge deciding on a case won't be qualified medically. They have to rely on the expert witnesses. Where if the judge is actually medically qualified and they understand the legal process as well, they're able to make a decision. Yeah,
it makes a lot of sense.
That's the more formal side of things. But
are you always on the defense side? Have you ever been on the prosecution side? Oh, yep, you have. So you've worked on both sides.
Yeah, you have to play a balanced hand. If you just simply defend all the time, then you become very, very, very skewed and towards becoming incredibly defensive. And that actually doesn't impress the courts a lot. They actually want balance. They don't want to see you advocating for one side or the other. Okay. So providing reports for patients who have been harmed is it's a skilled area to negotiate your way through without sort of being that guy at the conference that no one wants to speak to anymore.
I know, because I was going to ask, how do you go when the defense comes to you and they say, Dr. Cam, we need you to take a look at this. We feel this is unjust. Have a look, and you read through it and you go, nah, he's really stuffed up here. Yeah. Do they then go, oh, okay, they then try and settle it because they know that there's now a problem? There's no point going to court because they're going to lose.
Sometimes and in a very early stages, that's what I will do. I will tend to say to people, this is not defendable. Unfortunately, it's not about sort of sticking the knife in and twisting it and finding it. And there's nothing worse. There's nothing worse when an expert is instructed with a set of questions and they come out with 15 more different allegations that they've made up themselves along the way. That's not helpful to anyone. But generally what you'll do is point out the weaknesses and say, there are some things which just don't pass the bar test, the pub test. If it doesn't look right, it's probably not right. And also, things which are not tried and tested, have been done on the fly, or they're a little bit sort of out there, a little bit sort of new and novel. They haven't really been researched and tried properly. Patients are not guinea pigs. And you see that quite a lot. You see people who've read an article on something that's been reported on once or twice, and they start picking it up and doing it. And then if it does go wrong, they expect someone like me to try and defend it. I mean, and that's quite difficult. That's pretty challenging.
Yeah. Have you got any examples of podiatrists that you've gone through this process with that you can talk about?
I tend not to talk about.
Don't mention their names. Don't mention their
names. I mean, I can tell you a couple of things which really, certainly in the UK, this is relevant to the UK.
Yeah, so you don't not talk about a specific case. So if somebody was listening, they go, "Oh, that was my case," but things that you've observed where there's been common errors.
Yeah. Okay. So
or some similarities between what people are complaining about, or patients are complaining about.
Ingrown toenail surgery is a classic one. So all podiatrists, just about every single podiatrist in the UK, has the right to access, sale, and supply of medication, including some antibiotics. And I know that's different in Australia. You have to be an endorsed prescriber, but over here we've got that ability, and of course in the USA as well. Patients who come in with a ingrown toenail, they get into the podiatrist has a look, fiddles around with it, doesn't do anything, talks about a PNA. Patient then doesn't prescribe antibiotics because they don't feel they really want to, or they don't like doing that. They're sent to the GP. GP then prescribes something completely inappropriate. Patient then comes back. They do a PNA, phenolize things. Then the patient becomes septic, unwell, goes into A&E, has a X-ray, and they've got osteomyelitis in the big toe, and that gets operated on with a terminal tuft, so they lose the end of their toe, and then they claim against the podiatrist, saying that the podiatrist did not give them antibiotics, and the podiatrist's defense is, oh, we don't have them in the clinic, so we don't normally do that. But what I did is I sent you to the GP. The problem with that, Tyson, is the fact that the GP sent them to you in order to do the job as a professional specialist in that area. You then deferred care back to the GP, who's not a specialist, to prescribe antibiotics when you could have done it yourself. And if your defense is that I didn't want to, or I don't do it very often, or I don't really like it, you're probably going to have an issue defending that, because most people will turn around and say, if you've got the ability and you're licensed or registered to do that, then you're practicing below a standard of care expected of you.
Okay.
So, another type of case is where a patient who has got a sore medial arch and sore inside the ankle, they come to you and they can't do a tiptoe test, and they've got a slowly progressive unilateral flattening foot. So you decide to give them an orthosis. They come and some stretching exercises. They come back. You give them some more stretching exercises, and jack the orthotic up a bit more. It still hasn't got any better. They come back 6 months later, and now they've got a collapsed flat foot. And you try them in a Ritchie brace or something similar, and it doesn't get any better. And then they finally end up going back to their GP saying it hasn't got any better. They go to one of the local orthopedic surgeons who says, you have a tibialis posterior tendon rupture, which probably happened about 6 months ago. And if you'd seen me 6 months ago, then you wouldn't have to now have this pan-talar fusion. And at 38 years old, that's not good. Yeah. So understandably, that 38-year-old man is going to sue the podiatrist for failing to diagnose and failing to act appropriately. And it's no defense to turn around and say, well, we believe that just, given an orthosis can do the job. You've got an obligation to deal with the patient appropriately, refer them on, or send them for further studies and investigations and understand what's going on. What leads people into trouble is following blind faith in treatments, which they know are not going to work, or they just watch them fail and don't do anything different. We've got lots of things in podiatry that we still do that are not evidenced, and maybe it's okay to talk to other podiatrists about this sort of.
So going back to that podiatrist that made the orthotic for the patient, they come back in and it's not working. Yeah. If they then do further evaluation after that, yeah, then they're still covering themselves, aren't they? It's when they don't do the further evaluation. It's when they just go, well, I've done what I can do. Yeah, I did an orthotic because it fixes everything, bar hemorrhoids. And
this case perhaps is a little unfair because the one I'm thinking of actually thought the patient had plantar fasciosis and sent the patient for an ultrasound scan. And the radiology department did an ultrasound scan of the heel and said there's no plantar fasciosis there. But of course, had they actually turned the probe the other way onto the medial aspect, they probably would have seen a rupturine tibialis posterior, but they didn't. So the podiatrist relied upon the fact that the radiologist said, no, the patient hasn't got plantar fasciosis. But they didn't correlate the fact that the foot was beginning to flatten asymmetrically. Patient couldn't do a heel raise test and still worked on the basis that the patient had got plantar fasciosis, even though all of the signs were pointing elsewhere. So it was a real failure to diagnose.
And one of the classic things too would be, even if in their notes, they didn't do the heel raise test to start with and went straight to orthotics. So,
So I think there are a lot of times we see things going on where perhaps people are not really up to date with a lot of practice, or they're not necessarily up to date with good practice, or they do the same things day in, day out, even though they know they don't work, or the evidence is contrary to it. And you see that a lot. And the classic one of my bugbears is bunions and orthoses. From a medico-legal point of view and from a surgical point of view, there is absolutely no evidence whatsoever that I've seen that actually says that bunions can be treated with an orthosis. They can be relieved, the pain can be relieved, but they can't be treated. And you've got to be absolutely crystal clear with your patient about what you're trying to do. And so informed consent and consent is really, really super important. And it's not about putting down on your patient acceptance form or your surgical forms, I'm going to give you a 4-degree rear foot varus posted orthosis to, whatever. It doesn't mean anything to the patient. You've got to be crystal clear and say to the patient, I can't treat your bunion with this, but I can help some of the symptoms. And probably in 12 months, the effect is going to be lost, but it will help you make your decision as to what to do next.
Yeah.
So it's practicing in an appropriate way, and also not holding on to patients. Podiatrists are fantastic at holding on to patients. That's what I see through lots and lots of claims. We don't seem to refer on very often, and we seem to think sometimes that if we've got the foot, then everything we do has to be sort of based around our bag of tricks that we have, and it's the classic thing of, if you've got a hammer, everything's a nail. So if I'm an MSK podiatrist and I'm giving orthoses out as my mainstay of treatment and exercises, I will make your symptoms fit what I can treat.
Yeah.
So that's and that leads people down a bit of a path, and those are the cases that I tend to see.
Yeah, I remember one particular patient, and I've mentioned it on the podcast before, where I had a patient come in, sit down, taking a really good history with him, and everything he was telling me didn't make sense. He'd been to a couple of podiatrists before. He had orthotics made. He had seen his GP. He had changed footwear. He had done everything. This heel pain would not go away. It was hurting him when he was lying in bed at night. It was the same pain whether he was weight bearing or non-weight bearing. I'm going, this does not make any sense. Let's do some further tests. And when we did just the initial x-ray was the first thing we did, came back and he had a 4-centimeter tumor right in his calcaneus. Yeah. And he looked at that and he said, should that be there? I went, no. I said, which is why nothing else you've done has actually worked. But I found just that history from what he was telling me, asking really good questions, sort of pinpointed, this is not normal. To go down the same track that everybody else had done. And the thing is, I referred him on to his GP, went to a surgeon, got it operated on, it was benign, everything was fine. And I tell you, GC referred a lot of patients to me afterwards.
Yeah.
He was extremely happy.
Look, that works. And you do see plantar heel pain is a common one where you see patients who have had not the best outcome. But it's because the diagnosis has been really interesting. How many podiatrists diagnose heel pain as plantar fasciosis? Unless it's right at the back, a big on the back, it's either a pump, Haglund's deformity, or it's plantar fasciosis. Those are the only two diagnoses that people make. And actually, you can probably, off the top of your head, reel off 5 different potential diagnoses that it probably could be, other than plantar fasciosis. So I just think the reality is that sometimes we get into that real checkbox podiatry regime of we see the patient, they've got heel pain, we don't listen to them. They say, oh, right, yeah, okay, well, it's post-static dyskinesia. It hurts when I get up. I know what you need. And you're reaching for the orthosis prescription form or the off-the-shelf orthosis before you even know it. And as they're talking to you, you've slipped into their shoe and you've made your diagnosis out the door already. And the reality is that you don't really check. So there's a lot of things that when you end up with these situations where there's a claim, you're being judged by other people who are invariably going to be inside the profession, but also outside the profession. You'd be surprised at how often foot and ankle orthopedic surgeons are asked for an opinion.
Yeah.
And so they will say things like, well, where was the x-ray? Where was the ultrasound scan? Did you do a heel compression chest? Did you check for that they might have had a stress fracture of the calcaneus? There's lots of different things that are missed because we get into this checkbox system of
when it comes to training, is this a fault of the university? Not every university, obviously not the one that you're at, but is this a fault of the university not making the students think outside the box, that when someone comes in with certain problems, don't put these blinkers on, keep your thinking really broad and then work your way back once you eliminate things?
Yeah, look, I think it's certainly worthwhile mentioning that, because the one thing that I found when I went to UWA was that I was very lucky. I had a great group of people to work with, but what we started to do is we started to change things into being a medical diagnostician, as opposed to that typical podiatry thing about, it drives me nuts. It's one of my bugbears. Anyone who knows me knows that I'm not interested in whether they've got piriformis pain when they're talking about their big toe that's stiff, or their glutes are not sort of powerful enough on the left side, or they've got a, whatever. I'm being facetious, but you know what I mean. That they've got a big toe joint that doesn't go up and down. So before you know it, someone has started to do a full biomechanical, looked at the rear foot, looked at the sort of, medial deviated subtalar joint axis, and gone up to the tibial all of that stuff, and started going on to the core strength and giving them prescription exercises for their core strength. And you sort of sit there and say, what about the toe, the arthritic big toe? And so you can see how patients get looped into the system. And then 6 months later, they're saying, well, I kind of went along with it because I thought that actually that seemed to be going well, but actually I've still got my big arthritic big toe. There are times, Tyson, where we have to say, okay, there's nothing we can do with you. We might be able to give you a steroid shot into the toe, but if that doesn't work, and we can probably support it underneath, not with a biomechanically correct orthosis, but just a simple device to block the motion of the toe joint. But if that doesn't work, it's off to have it fused.
Yeah.
And that's good medical practice. And I think the thing about podiatry is that we sometimes lose the sight of what the patient's there for in trying to make it very much more scientific than it needs to be, or perhaps looking at bigger remote causes. And it's the same thing of like, well, if we can't open the toe up and screw the two bits of bone together, we can't offer that to the patient. We'll have to refer them on. What are we going to do to keep them?
Yeah,
I know.
Okay.
We'll come out with some stretching exercises. We'll come out with an orthosis, and we'll do some shockwave, or we might do some dry needling. I think you guys call it in Australia.
Yeah.
And all those things may reduce some of the symptoms, but they're not going to treat the actual problem. And that, if the patient becomes unhappy and starts to talk about claiming, you can bet your bottom dollar someone will uncomfortably point out why you didn't send them for an x-ray, and if you couldn't do anything more with that patient, knowing that x-ray showed quite a significant arthritic joint, why didn't you send them on for surgery? Because that's what would have been the right thing to do. And you have effectively now got a claim on your hands where the patient has had delayed suffering because of your actions.
That all makes sense. What happens to, because I'm just looking at the time, so just one last thing I want to find out. Say somebody goes through this process, they get that first letter from the solicitor, the stomach drops. Oh no, they do contact their insurer, which they do what I didn't do. They contact their insurer, they go through that process, they lose. There's a claim made against them. Like what happened with you? There was a payout.
Yep.
What do they do afterwards? What?
Look, it's a really, really important topic, because the first thing that you do is, you reflect on what's happened. You breathe a sigh of relief, sometimes 3 years later afterwards, if you haven't.
I know, because this is never a quick process, whether this is going down the whole legal thing about being sued, or even just dealing with the registration board in any way. Yeah. It's not fixed in a couple of weeks or a couple of months. It's years.
No, and so, look, I think the one of the biggest things is getting some support. Talk about it openly. I mean, if you're a podiatrist and you've been claimed against, you're going to go through a whole bunch of feelings. You're going to go through, a bit of anger, grief, loss of reputation, fear. Am I going to lose my job? Am I going to lose my registration? Will I be able to pay my mortgage? All of those things. You'll go through self-doubt. You'll go through criticism. You'll go down to having self-esteem on the floor. And you've got to pick yourself up and really, really start to look at things very dispassionately. So almost try and treat it as if it's someone else who's done this, so that you are looking as if this is just part and parcel of how you're looking at practice. Treat it as if it was a mate and you're helping them out with a case against them. Now, of course, that doesn't take away from what our registration boards say, which is we need to be self-reflective and understand and learn, which is entirely appropriate. But you've got to psychologically survive, right? So you have to really sort of put yourself in a place where you are able to deal with that, and that comes with support. We know that the research tells us that podiatrists or any practitioner who's under investigation, they normally perform at around about between 45 to 55% of their capacity. That's a huge reduction. So actually, people under scrutiny need a lot of support. And I'm not a great advocate of the boards, both in the UK, Australia, New Zealand, slapping interim suspension measures and interim practice directly against people. I think it's the quickest
I always say the board, whenever it comes with the board, I hope someone from the board is listening to this, because
I hope they're not.
I hope for you, I hope they're not, but for me, I don't care. Is they treat you like you're guilty until proven guilty.
Yeah, it's because they're function, but this is what people don't really get, and I know we're short on time, but one of the quick things to say is that being sued is a legal process. It's taken out of your hands. You write your statement, you write everything you can, you pass it to the lawyers and they deal with it for you. And there's kind of a thing in the UK, you get sued, so what? But the insurance claim is a bit tricky, and financially it can be always a bit challenging. Your next year you get renewal, but actually the one that can really, really smack you around the chops is the registration board. And I did just going very quickly back to the reasons that people get sued. We talked about practitioners squealing on other practitioners. I did a 28-day hearing a couple of years back on a podiatrist who had been accused of sexual misadventure and sexual assault by doing gait analysis on people naked. And
that's different.
That was,
it's okay if you called the naked podiatrist, then it sort of goes hand in hand. But they weren't, obviously.
They weren't. No, and actually, I was on the defending side. I was very pleased to be able to defend that, and it was successful. So that person managed to get through their registration allegations quite nicely. Partly because actually there was evidence to suggest that the people were clothed, but it actually started because someone in competition had really, really wanted to get them away with, and that person had to endure a number of years of speculation. And look, they were dealt with fairly. I'm going to say that they were dealt with fairly, probably by the registration board. But my God, that was an uncomfortable. An uncomfortable time for that person, and I felt very, very sorry for them, and I was extremely pleased to put an incredibly robust defence forward for them, and that involved really looking very deeply into what the scope of practice was, whether it was appropriate to do hip examinations, whether it was appropriate to do lower back examinations as a podiatrist. And we were able to put the case to the registration board that on balance of probabilities, that was an entirely appropriate podiatric thing to do, and actually no misadventure had gone on at all. But those patients, those claimants didn't sue, they complained to the registration board, and that is the ticket.
Because they're two different things though. One is being sued, like lawyers involved in your insurance, and the other part is a complaint, the registration board. So it's like two completely different topics, but the registration board can step in either way and suspend you while the investigation's going on. And then when you're found innocent, you haven't worked for 2 years or 3 years. No,
you're probably not. You're not in the profession probably anymore. To be fair, and the reality is that the courts are there to get justice for the person who's been harmed, or a tort has been performed against them. and damages are what flow from that successful allegation. The registration board has the mandate to protect the public. They don't care about you and your practice.
Yeah.
Only if you're not practicing to a standard. They're there to protect the patient. So if they have to protect the patient by suspending you, that's what they will do and justify. And I often think it's a very unfair process. And certainly in the UK, the GMC, the General Medical Council, has really been taken to task for being overly harsh and overly preemptive in its decision-making against proof, where they should have had a balanced view. So I quite enjoy that side of it as well. In fact, I enjoy that more because that is where you can really, really mount a defence, and you don't have to work so much to the court's directions.
Yeah,
you can be as unbiased and defending as you want to.
So, because you're still working with lawyers, that person would.
Yes.
Like I've dealt with the registration board a few times. Like I said, never over anything clinically. More, this may surprise people, but sometimes I say inappropriate things, and not in a bad way. Just one in particular. This went for 5 years with the registration board, backwards and forwards, and I don't know how much money it cost me because I called the patient a tool, which he was. Yeah. That was my defense. He is a tool. Yeah. Anyway, but I shouldn't have said it. I shouldn't have said it. It was unprofessional of me to do it. And I put it in writing too. So I shouldn't have done that.
It's not slander or libel if it's true. That's an adequate defense.
I know, that's what I said. And then since then, so of course, I was guilty until proven guilty. But I had to get a lawyer involved to defend this whole thing. It cost me so much money. Then I had to do a 1-day course on professional ethics and communication, which cost me $5,000 to do this 1-day course.
Wow.
Yeah. And of course, and then as I'm saying to the people teaching the course, so how much is the kickback you giving back to the registration board? Which one of is your relative? Anyway, which didn't go very well either. Which,
like probation, I'm surprised you got signed off. It's community service.
I know, but what I found funny about that whole, the course I had to do, I said, so what happens if I fail this? And they went, oh, there's no pass or fail. You just got to do it. I said, no, it doesn't matter even if I don't agree with anything I've done here, that's ticking the box and says, everything's fine. Good part, I worked right through that whole process. It didn't make any difference to me. But when it was all finished, I said to the people that did the course, patient's still a tool. That has not changed my opinion in any way. And since then, he proved he was a tool. Sends me a death threat, usually a death threat once a year. Haven't had one this year yet. So
nice.
Yeah, he might have died.
Well, I guess the learning point from that course is that the patient remains a tool, and they've got every right to remain as a tool, but you're just not allowed to call them a tool.
That's true. And I shouldn't have done in hindsight, I shouldn't have written it down. I shouldn't have said that. I was totally in the wrong, and I just accepted it. But it was the process that you went through over this 5 years, and just the amount of sleep you lose because you don't know what the registration board is going to do. You don't know how they're going to react.
It's really important in those initial statements that you with the registration boards, because they're looking for you to be a reflective practitioner, it's really, really super important that those types of early statements are very reflective of the fact that you may have caused a patient some distress, and that you're contrite about that, in the fact that there's an act of contrition there, and saying that I'm sorry they feel this way, but I did this and this and this and followed the process, but I think I could have done that better. Completely different tactic in defending that sort of action, whereas opposed to the courts, if the patient has already started an action against you, well, you can be as fairly robust and factual as you want to be. Just strip the emotion out of it, but be factual and robust. And that's where people like me, hopefully, as an expert witness at least, can help. And what helps me though is that very factual, stripped of emotion, a statement early on. I mean, I can read through the emotion, but it's just helpful when it's very much more factual, and it gives me a heads up about what your thinking process was and why you did something, and it can explain why it's there. So it makes my life a lot easier, and it makes the defense a lot more powerful. I think I guess the last thing that's probably really important is notes. People talk about, they go on dry note-taking courses. If it wasn't noted, it didn't happen. And that's true.
Yeah.
By and large, it's really true. But I always say to people, make sure you put in the notes that you explain to the patient what you did, and almost in a conversational style that they understood things. I mean, very quickly talking about surgical cases, the majority of time I see attacks against the consent form. This patient did not consent because they didn't understand the language. Well, they didn't, because it said you may end up with pain, swelling, infection, poor healing, poor outcome, osteonecrosis, failure to heal, or overcorrection or undercorrection, and repeat surgery. The average patient, and possibly DVT 0.3% and maybe PE 0.3% as well. The average patient hasn't a clue. So you've got to really talk about things, and you say to patients what's important for them. The duty to inform is incredibly important. We have something called, for the life of me, I've just forgotten the name of it. It's such an important case over here. It'll come to me. It changed the way that we started to inform patients. It's the duty to inform in Australia, which effectively says you've got to tell the patient everything that's important to them, even if it's not important to you, something that they may attach importance to. So, for example, if you're diabetic and you have a risk of infection, normally, which is 0.1 or 0.3 or 1% of the time total, but if you're a diabetic and the risk for you is 15%, well, it's important.
So they know that.
Yeah, you have to basically scope it. You can't just say, we have a 1% infection rate, madam. But for you, because you're diabetic and because you're not so greatly controlled, etc., it could be high as 10 to 15%, which means if you get infection, we're going to have to treat it really aggressively, very quickly. We may have to bring you into hospital and give the injections through your arm until you're well enough again. And by the way, it'll probably mess around with your diabetes, so we're going to have to do some work with that as well. And we may have to go in and clear the muck out of the wound if it gets infected. Are you okay with that? Are you ready for that? Is that something that you're prepared to do if we have a problem? I'll be upfront with you. I'll be honest with you if that happens. If I think it's going to happen, I'll look after you. You look after me, and I'll look after you, and together we'll get through it. And you note that conversation down, that you've had that conversation. You don't just rely on your consent form, which says pain, swelling, infection, poor healing, poor outcome.
Yeah. That makes sense. So going back just to that last question before, so if a podiatrist goes through this process, they pop out the other end, there is light at the end of the tunnel and life will go on. Yeah. But I always talk about with insurance in general, when you take out insurance, you're betting the insurance company something's going to go wrong, and they're betting you something won't. So I think when you look at it that way, if you're paying insurance every year, things can go sideways, even if it's out of your control. And I think you've just got to, if that happens, you go through the process and just realize there is life at the end of the tunnel. Don't leave the profession over it.
Don't leave it. I mean, I was really interested in your Why Did I Leave the Profession series a couple of weeks back. And I was waiting for someone to say, I got sick and tired of constantly getting claimed against or constantly having to worry about negligence. And I guess if you ask surgical people, it's one of the things that's on their mind. They get sued 2 or 3 times, and they know that they're going to go and meet the threshold of going before ARCRA or the HCPC in the UK, which means that they are having to deal with significant stresses in their day-to-day practice, which could affect or stop their career. So it's super important that your mates are there to wrap around you. You talk about it. You won't find a room of podiatrists where one person hasn't faced some allegation of some sort.
Yeah, well, I almost left a couple of times, nothing to do with being sued, but purely because of the registration board, just of other podiatrists complaining about certain things that I was doing. And every time a complaint went in the registration board, it was 12 months, 2 years before you got through the end of it. And when you're dealing with this every single year, I used to think, sometimes I should just leave. I've had enough of this. But it was only because I'm pig-headed and stubborn that I went, no, I'm not gonna let them run me out, because I haven't done it. And every single time I've gone through, other than calling that patient a tool, every other claim that was ever made against me by another podiatrist that I did this wrong or I did that, I always came out of it fine. but the process was just really draining. But I thought, if I leave, then they've won.
Yeah.
Well, and I like to win.
I think things are changing. You know, I like to win too. And you know, the litigation side of expert witness work is really, really interesting. I mean, and just to preface it to say, you know, our job is not to be a lawyer or to defend or otherwise. We're there to help the court decide on what's gone wrong and why. The other side of the work that I do with the dispute resolution is very different, and that is about mediation and arbitration, and that does rely on having a good legal understanding of things, you know, tort law, negligence, contract law, disputes in general. But things are moving towards that way to try and include that, so that we can sit down with people in pre-action protocols where we get the chance to sit down with clinicians and the patients and try and do things to intervene so that they don't ever go down that formal claimant track.
Yeah.
So that, as I say, it's a good opportunity. It's a really, really strong, powerful tool to encourage patients to open up as to why they're unhappy and how they've got there, why they got there. But to engage with clinicians and tell them why they're upset, and also for clinicians to hear why people are upset, because there are some people out there, going back to your very early point, that, you know what, they've been sued or taken action or had complaints against a lot of the time. And you know, some of those people have some very interesting ways of dealing with patients. That classically, they'll do something, then abandon the patient, and they need to realize that actually those sorts of things have an effect on people. If you don't keep your patients close, if you're not confident with them, and you're not sort of complimentary about them, you know, patients get unhappy. They're people. So those sorts of measures are helpful, and I think they will help to retain people in the profession and help to retain the confidence, because there's nothing worse than having your confidence on the floor because you've been knocked a few times. So, you know, different process using the dispute resolution processes, different process of support, having our organizations supporting us through those processes as well. We're rubbish at it. You know, we really are. Look, in the UK at least, and you know, possibly in Australia as well, we're rubbish. If you contrast us against the medics, they have significant support mechanisms. They have medico-legal advisors who are doctors and lawyers, dual qualified. They contact you within the day that you've had a claim, and they literally hold your hand through the process. They are an interface between the clinician and the insurance company and the lawyers, and they buffer the workload, and they buffer all of the nasty bits. So they work as a team to try and deal with clinicians, and also they understand that clinicians are extremely stressed and are not going to perform very well in multiple areas of their life. We don't have
that. Makes sense.
We should have that.
It's like I'm probably going to break this episode into two parts because it's like, I think it's really important, and because I've got just a couple more questions. So I'm thinking, well, why end it now? I'll split this. I'll edit this bit out, not in the video, but in the audio. Well, so just got another question. Is a new graduate comes through, they've been given, you can only teach so much at the university. You can't teach everything. So then they go and get their first job. They're working for someone who promises good mentorship. They get that job and the mentorship does not exist, or it's very poor. There's hardly any training. Their skills start to go down. Now they're working for somebody else and they make a mistake in the clinic. Who is liable? Is it the employee who's made the mistake, or is it the business owner who has promised mentorship but never gave it?
So if you're an employee, you are under vicarious liability of the business owner. So the business owner is responsible for the activity. So the patient will claim against the business or the practice. That's slightly different if you're an associateship agreement or a subcontractor. Then you retain your own insurance and you retain liability. So I mean, that's the technical answer, but to your point, realistically, you know, I think the business owner has to take a large rap on the knuckles for that, because if you're working to the protocols that your employer has set you, and you're not doing anything out of the box that hasn't been agreed, you're not doing anything weird and wonderful, and things go wrong, well, then you can quite adequately and point to the employer and say, well, I'm following the directions of my employer. So yeah, the claim is against them.
That's really important.
And it works both ways, because sometimes, you know, you get people who, of course, also on the converse side, they're doing things they don't want to do. I remember, I worked in a crazy organization where the person decided that they didn't want to use phenol anymore for PNA. So they wanted to use trichloroacetic acid based on one study and of 13 patients or whatever it was. And it wasn't that it was completely wrong. It was just, I wasn't comfortable, had never used trichloroacetic acid at all as a way of destroying a nail matrix, didn't know anything about, no training, and was pushed into this situation. And I hated every single minute. I did one PNA and that's it. I tried everything to avoid doing them ever after that until I changed jobs, mainly because I was doing something which I was not happy with. And so if anything had gone wrong with the patient, I could probably adequately turn around and say, well, I wasn't trained, et cetera, et cetera, et cetera. So from a legal standpoint with a claim, then I probably could have got away with it that way and pushed liability onto my employer.
Yeah.
But from a registration board, they would have turned around and said, well, you should be doing stuff that you are happy to do and you know how to do it, and it's your obligation. And that's that conflict between the young practitioner and the employer, because the registration board says you've got to stick up for yourself and speak out if you think something's not right, and advocate for that. But if your job's on the line and you've got a very strong employer who's got very robust procedures that they want you to follow, it's really, really difficult, isn't it? So
it is, because like I used to use trichlor acid for.
Oh, did you?
Yeah,
okay.
Yeah. That's when I went through. That's how we had the option. There was phenol, trichlor acid. Up here in the tropics, we were sort of told phenol doesn't last as long up here. So I used trichlor, and I did hundreds and hundreds of PNAs with trichlor, never had a problem. So anyone that came to work with me, and no one ever, when I said this is what we use, I think the people that came and worked with me, that's what they were using prior. So it was,
But the thing is, you probably also worked out pretty quickly whether someone had no experience at all with it and didn't know anything about it.
Oh, I would never let anyone do, even I didn't care where they came from. They didn't do any nail surgery until they'd sat in with me doing a couple first, and then I might watch them do it. So it's sort of that, sort of watch one, do one, teach one.
Yeah, so it's not crazy doing the actual technique isn't crazy. What's crazy about it is the fact that people get chucked into situations where
if you've never used it before, it can be really, like when I was explaining how to use it, you'd have to take off a certain amount of the cotton wool, or have to get these specific ones you used to be able to get from the States. Yeah. And you'd only put a certain amount on that, and you could only put a certain amount in at a time. If you just tried to do it like normal and go ramming, the acid, if it went all over the toe, would burn the rest of the toe. So it could be damaging if you didn't know what to do.
Yeah, I mean, it's like, like the it was a while back, there was a young house surgeon who simply was cannulating people, and I think he managed to have a record number of thrombophlebitis in the arm of patients because he didn't know how to use the cannula system that they had in that hospital. No one ever showed him. He was just expected to go and use the system, different cannulas, and he kinked the thing and jabbed the vessel a couple of times, and it was and apparently the story goes that he was quite uncomfortable, but he just didn't want to say anything. He wasn't sure, and no one checked that he knew how to cannulate people with this system. He knew how to cannulate people, but not with these particular types of cannulas. Yeah. So it's really, really important that as an employer, you check with your staff that they do know what they're doing, and maybe run through some competencies early on and just check them off to say, are they competent? Because it's very, very challenging. I think that young podiatrists coming out of school who've learned one way, or learned one, maybe a couple of ways, but they've definitely followed what their lecturers have said, and they will be, they'll be challenged a lot of the time.
So if somebody is trained, if somebody gets a job somewhere and they don't get the mentorship that they need, and they've come out with a certain amount of skills from uni, but then they're working with somebody else who just has them doing home visits in nursing homes and all the general foot care, and all their biomechanical skills start to disappear.
De-skilled. Yeah,
they're de-skilled, and then all of a sudden, bang, they're thrown in. Oh, you've been in now 2 years. You can start seeing biomechanical patients without retraining.
Yeah.
Then I can see how that causes problems as well.
Yeah, I mean, it's a disaster waiting to happen. You're very, very likely to have some poor outcomes.
So
And a
the
very
employer
stressed
is quite liable in some of these cases.
Yeah, I mean, the employee, the employment law, the contracts around employment law are different. They're master servant contracts, which it harks back to the old ages, doesn't it? Really,
Yeah.
but it is a master servant situation. You effectively go to work for someone with a set parameter. You sign a contract, which is your terms and conditions of employment, but you have a job description, which is a job to do. And by and large, you do what you are asked and to do, and you don't deviate from that plan, because if you start deviating from that plan, well, then you're suddenly working outside of vicarious liability. So you can't just go ahead and do something, especially if it's been expressly said you can't do that. So you've got to be cautious as an employer that you are allowing your practitioners to practice in a way that gives them the ability to evolve their practice. But the practitioner also has to be careful that they're not going off piste and starting to do things that it's not actually supported by the employer. So yeah, it's important.
Yeah, when I did the 12-week podiatry business reboot, part of that, we looked at recalls, we looked at reactivation, and a big part of it was incomplete treatment, identifying incomplete treatment. And the best way to identify it was having treatment journeys all documented. Patient comes in with this symptom or these type of problems, and really documenting everything that you want done or that should be done. So when a new person comes and works with you, they've got a roadmap to actually follow all the way through. Yeah. And so I think that is really important for every business when you're employing someone to have it documented with all the different problems, put together your podiatry manual. It's part of your training. It's something that they can go back to, and it's something that keeps evolving and changing because things change.
Well, here's a classic one. Look, doing steroid injections, really you should have a standard operating procedure of how to do that. Because even if you've done 100 million of them, going back to your standard operating procedure is important to be able to show that you've got a documented process to ensure that safety is important and is paramount for your practice. So you can rely on that document if a claim comes. One of the things, for example, with ultrasound guided steroid injections, which we do a lot, they'll often say to you to take an image of the lesion, a screenshot of the lesion, and then one of the needle either in plane or out of plane, but to show that you've got the needle in the right place. And things like your standard operating procedure says, don't inject the Achilles tendon. It's got no tendon sheath. If you want to inject the Achilles bursa, you have to show under ultrasound guidance that you're in the right place and you're not stuffing depomedrone all around the tendon, which isn't going to do it any good. So, but in a standard operating procedure, that's important, because if you've got a podiatrist who suddenly goes and gives someone an injection, ruptures a tendon, and they turn around and say, well, you told me to go and do that, but it doesn't say not to do it there.
Yeah.
You can turn around and scratch your head and pull your hair out, what little of it I've got left, and say,
oh, yeah, that's what happens to us.
Common sense should reign, but actually common sense is the last thing that you can rely on when it comes to defending a claim.
I think there's a lot of employers that will be listening to this at the moment who are going to be going back into work tomorrow going, I think I need to start documenting a few more things, because I was a really huge fan of taking photos of everything. Yeah, person has a lesion, they come in with a lesion. I want to see a photograph of that as part of their file, because if it gets better, I want you to keep taking photographs. If it's getting worse, I want you to take photographs.
Yeah.
Whether it was nail surgery, to me, there was a photo says 1,000 words. And I tell you, the amount of time, you remember that the person I mentioned way back when we were first talking, that I got the letter from the solicitor. What that letter was saying, my patient came in and saw you with a perfect foot, and then you made an orthotic and it caused this ulcer on his foot and he wants to see you. That's what it was all about. When I wrote back to him, I didn't just say, no, I wouldn't give you my insurer, but I said, but here's some photographs of your patient's foot when he came and saw us, clearly with a big ulcer when he first came in. And did he then tell you that he goes to Thailand for sex holidays? for 6 weeks a year. Did he mention this? Because he was on his way there after seeing us. And I think that was part of why they just went, we're not going any further with this, because we had photographs of this person's foot.
Yeah.
And there was already there was already a lesion there, but this lawyer was saying there was no lesion and we caused it.
Yeah.
So I love photographs.
Photographs are really great. I mean, you get the consent at the start to say that we're going to do this, take photos, and I think they are really, really helpful. And we probably don't do them enough in podiatric practice. We probably, I mean, the wound care people would argue that they do a lot, and that's great. But I think in regular podiatric practice, we probably don't do enough to justify why we do things. We probably don't investigate enough, or we rely heavily on our clinical examination and less on the sort of things that can prove our investigation, such as X-rays or such as ultrasound imaging. You've got to really, I think at least, you've got to really back up and justify what you're doing these days. It's no good turning around and saying, well, the clinical history gives me enough information, because yes, it probably does. And you probably can work on that, but it doesn't prove anything. I use ultrasonography for plantar heel pain quite often, not because I don't know that it's plantar fasciosis, but because sometimes I just want to see how thick the plantar fascia is, make sure there's not a rupture or a tear, make sure there's not an infracalcaneal lesion, but to document the fact that it is plantar fasciosis and that's what I'm treating. And sometimes those sort of things are really, really important. We just don't do them enough in podiatry. And I don't know why. Every other profession seems to do it, but we're just not super good at it.
Yeah, I used to tell every person that when they were working with me, every single patient that walks in the room, sits down with you, in the back of your mind, think this patient is going to sue me. So
right,
just be prepared. The patient sitting in front of you could be suing you. So regardless of what the problem is, what do you need to do to make sure that never happens? And that was my thinking with every patient. What do I need to do to make sure I never get sued by this patient? Therefore, do the bloody right thing. Just do the right thing. Don't cut any corners. If it's going to take longer to get the diagnosis, then take the time to actually do it. Don't rush people through.
No.
And I used to get frustrated when I'd say any patient that comes in who has any form of symptoms, if they leave without there being another appointment, you have not done your job. I don't think you've done your duty of care, because they've come with pain. If they're leaving with pain and that's all you've done nothing else.
Yeah.
I said there has to be there has to be another step. Whether it's you've tried something, reappoint, you've referred them somewhere, there's got to be another step for them.
Well, look, actually, I mentioned before about one of the biggest, the number one reason that people sue is actually unremitting pain. The pain doesn't go away. Yeah. And, people don't come in wanting to know about their forfeit supinatus and their, partially compensated reverse. They've got pain. And frankly, if you leave your patient in pain, don't follow them up. In crazy situations where sometimes in pressurized hospital services or bigger departments, you see the patient, you assess them, you give them an orthosis, write them an exercise prescription, and so I'll follow you up in 6 weeks with a telephone call to see if you got any better. And the question is, are the orthoses comfortable? Yes. Great. Job done.
Yeah.
Are they in pain? Oh yeah, I'm still in pain. Well, are they comfortable? Yeah, they're comfortable, but I'm still in pain. Well, they haven't worked. They haven't done what they need to do. And it's about following patients up. And you'd be surprised at how many patients actually still walk out in pain, having left a consultation slightly confused. And you see it in the notes. You can literally look down, you get a big A4 or a 500-page PDF of notes, and you can see clearly where multiple times the patient has said, but it still hurts, I still think there's something wrong. And they've almost had to work against a clinician convincing them that they're not in pain, that there's something not there. If a patient's in pain, then something's not working, is it? And so you need to document these things as you go, and you need a treatment plan. And you need to show in your initial thoughts that this is what the treatment plan was, and be clear and concise, and make sure the patient was on board with that as well.
Yeah, that makes total sense. Everything you've said makes sense. And I hope that everyone who's listened to these 2 episodes, that we've put them back to back, that they actually take some notes, and they don't just go, oh, that was really interesting, I should do something about that, and then in a week's time, they forget about it. Is if you're listening to this now and you're thinking, wow, okay, I haven't been a great mentor. Maybe I don't have treatment plans. I'm not training people properly. Maybe I'm cutting corners with patients. Is take some action on this and start making some changes in your practice.
I think one of the things that I would probably ask people to think about is, if you think that what you're doing is practicing at the lowest level because it's the lowest risk, it's the podiatry colleagues out there who for whatever reason have said, I'm really happy with my routine essential care practice. I don't do any nail surgery. I don't do orthotics, biomechanics. I don't do shockwave. I don't do anything particularly like that. I'm just happy with, doing very routine care.
Yeah.
That's fine, provided that you only set your services at that patient. But you have to be very careful about claiming, and I'm going to say something incredibly controversial, so forgive me.
Oh, no, controversy is great on this show.
You'll be very careful about claiming to be a podiatrist.
True. I agree with that.
If you're pregnant, so push the level. If you can prescribe antibiotics, and if you've got these endorsements, then use them. If you've got an ultrasound machine, and a diagnostic ultrasound machine, use it. Or if you don't know how to use it, go on a training course to do it. So practice at the highest level you can, rather than the lowest, because your patients expect that of you. When they come to see you, they're expecting a really, really solid diagnosis and a solid treatment plan. And if you can't do a solid diagnosis because you don't know what it is, and not every diagnosis is straightforward, but you've got a real clear treatment plan and you're practicing at the highest level you possibly can. Look, I mean, for our American colleagues listening over there, and they're going to hate me for saying this, they don't, their doctorates in podiatric medicine practicing at that level, what they're doing is they are practicing in a structured medical way about foot and ankle conditions. That's the difference about how they approach things. They're not scared to pull out a prescription pad, give an injection, send you for an x-ray, or open you up if you need to do that. And not everyone can open you up, and not everyone's supposed to be able to do it. But the difference is that, and I'm not advocating for the American system, by the way, I'm just saying that the difference is that they are true foot doctors.
Oh,
and
yeah, I agree.
We've got lots of practitioners all across the paradigms, across the countries, where we've got people practicing at an incredibly high level, and people who are perhaps just happy at that, what they think is a very low risk. That patient who comes in with that lesion that you debride every 6 weeks for 2 years, that verrucoid carcinoma that you think is a corn or is a verruca that you just sort of drop in salicylic acid on, those are the patients who go bang. And the other ones that surprise people because they've just done this low level, I don't like using antibiotics, I don't want to do this. And you kind of have to, you kind of have to say, look, isn't it it's time to pack your bag and go home? It's almost
Well, could you imagine going to a dentist and you go in for a scale and clean, and he says, "Oh, you got to, no, I don't do fillings. I don't do extractions. I just do scale and cleans. No, I don't do crown and bridge work. I just do scale and clean." You'd be going, "You're not really a dentist, are you? What are you doing?"
You're a dental hygienist. You're a dental hygienist. And I say, "No, I'm a dentist." So but you're a dental hygienist. No, but I'm a dentist.
Yeah, and I think even some of the dental hygienists can do simple fillings, can't they?
Yeah, they can. Yeah, that's true.
So but I know what you mean. There's some people out there who really the podiatry hat should be taken off of them, and the old chiropody hat should maybe be put on them.
Maybe it is time to sort of think
split
about
the profession. Let's split the profession.
Yeah.
Except if you're in Canada, because they call them chiropodists in Canada, yet some of them extremely practice at a very high level.
Yeah, I think.
So now it's complicated.
Canada's a different. Yeah, it's a different one, I think, over there, because they've got DPMs, which are American trained, have done a residency, and they are podiatrists, where the rest of them are chiropodists, despite their level of training. So everyone who's not North American DPM trained,
it's very complicated.
Yeah,
it is complicated, because I know I've got a few people over there that I know in Canada who are technically chiropodists. That's their title, but they're podiatrists. They're no different to podiatrists in the UK and Australia, New Zealand, South Africa. They're podiatrists.
Yeah, I think I guess the message is try and practice at the highest level you can, and don't be afraid. And actually, if anything that I can illustrate in a good way is that sometimes practicing at what you think is the lowest level to reduce the risk can actually be risky, because you're not really actually treating people well if you're seeing the same caseload. So that patient with heel pain that's coming in, and you're saying, you're not really examining them, but you're doing your very low risk practice. You're saying, right, well, I'm going to give you this insole that I've got, you know, over the counter. It'll probably be fine. But, you know, if you don't check it out, and if you're not interested in investigating why they've got the problem and looking at it further, you're not really doing your patient much good. And actually, at worst, you could be missing things. The very rare calcaneal fracture, the very rare intracalcaneal tumor. But yeah, they can happen, and they're probably the case where you miss it, and the ones that do cause you to think whether or not you want to keep on doing this for the next 20 years.
Yeah, and that comes back to that example that I said, you know, the podiatrist I know in Cairns, who I think practices at an extremely low level, but probably just hands out the odd orthotic here and there, or the odd inner sole, and probably, like they said, they're good at managing patient complaints. They probably are. And when the handler go, hey, this isn't an area that I normally deal with, here, try this and just see if this works. Doesn't work. Oh, well, you know, we always said that it may not work. Oh, okay. And they just sort of get away with it. So I'm just looking at the time, better wrap up. Otherwise we'll break this into like a 4-part series. But it has been really, really good. So Cam, I want to thank you for coming on the Podiatry Legends podcast again, sharing all your knowledge in this area. I hope people are taking a lot of notes and are making a change to the way that they are practicing podiatry because of this particular episodes.
Well, look, thank you very much indeed. If anyone wants to ask me anything more, then jump onto my LinkedIn.
Yeah, how can they reach out to you?
Yeah, LinkedIn is always good. It tells you what I've done. And you can see what my experience is, but also where I'm leaning towards in terms of dispute resolution. If it resonates with people, or if it's something they think is helpful, that can be helpful, then send me a direct message. Happy to have a chat.
Yeah, I'll put all your details in the show notes anyway. If people need to, they can get them there. And just a reminder, find you on LinkedIn. So Cam, thank you very much.
Great, nice to speak to you.